Hello, everybody. My name is Matt Nepute. I am the newest attorney on Utah Legal Services housing team. We deal with eviction defense, and as part of that, we will often deal with eviction expungements. That's what I'll be presenting on today, is Utah's new eviction expungement law that came into effect last July-ish. Okay. Yeah, go ahead and next slide, please. Next. There we go. So the reason that expungements are so important with evictions are because of a device called a tenant screening report. It's something that I'll explain. Next slide, please. On the next slide here, which is it's a unique kind of consumer report. So usually when people think of consumer reports, they're thinking of credit reports, which kind of detail accounts they have open, bankruptcies they may have had, that sort of thing. A tenant screening report is a little more complicated than that, and in other ways a little less complicated. It contains a regular credit report, but it also has a public background check for things like criminal records, terrorist watch lists, sex offender registry, employment verification, and importantly, housing court history. This is a unique piece of information that is only ever reported on a tenant screening report. These reports have been around since about the late 1980s, right when Robert Stauffer wrote a really great law review article about this, in which he called a tenant screening report a large machine that reviews your life to determine if you're worthy of housing. This is basically what a landlord gets at the other end of a tenant screening report when a tenant applies to housing with that landlord. They can scroll down and get some more detail, but typically, right at the top, most tenant screening reports have a yes or no. And a big part of what can make or break that yes or no is whether there are evictions found in the public record. So the way this works is that if you've been evicted, if you've been the defendant in a lawsuit that is marked as an eviction lawsuit, and it's less than 7 years old, the furnishers that gather information in bulk from court systems around the country will include that, and that will count as an eviction on your record. That's what people actually mean when they say they have an eviction on their record. It's not on their credit report, and it's not a matter of whether they got removed or not. It's that they got sued in unlawful detainer or whatever jurisdiction equivalent it is in another place that puts it on their record. And this can obviously make it very hard to seek new housing, as it's basically going to knock you down the list as compared to any applicants you're up against. Next slide, please. So how do we get rid of these evictions on our tenant screening reports? Well, there's two options. You can wait 7 years, which is just the typical statutory period for most kinds of information to roll off of a consumer report, or you can try to get the record expunged. And in Utah, there are 3 ways to do that now. Next slide, please. So there are new paths to expungement, and I'll go through them now. Next slide. The first is expungement by stipulation. So the statute is very short and sweet on this one. All parties to an eviction may stipulate in a settlement agreement to the expungement of an eviction. So what used to happen is if one or both parties asked the court to mark a case as sealed, which is de facto an expungement, the court would have to make a decision based on a really unclear set of judicial codes about whether the interest of sealing the record outweighs the public interest of having court records be public, that sort of thing. I call it expungement by vibes. We don't have that anymore, and this is the unambiguously good thing to come out of the new expungement law. Now, if the 2 parties agree, it's a done deal. The judge just seals it up. And next slide, please. Automatic expungement. This one is not so great. So the automatic expungement process applies if a case has been dismissed and 3 years have passed since the filing date of the eviction. And then there's a couple of other requirements that tend not to matter that much, but the 3-year waiting period is, of course, the big issue here. That's a very long time to walk around with an eviction on your record. And the thing that I think a lot of people don't immediately register about this is this applies even if you are sued in eviction, you go into court, you prove that whatever they're alleging, non-payment of rent, nuisance, whatever, didn't happen, or that their case has no basis and it gets fully dismissed. you are still waiting 3 years to get this off of your record. You are walking around with that on your record regardless. Go ahead.
They actually dive in to figure out whether there was basis for the case or whether it was dismissed.
Sometimes. It totally depends on the landlord. And this is the problem, is that that information is there if you want it, but sometimes you have to pay more depending on the screening service you're using to get a more detailed report. And sometimes you're just looking at that yes or no at the top because you've got a stack of 20 applicants. But some landlords do care about that distinction, but enough don't that it causes some serious systemic problems. Because this eviction expungement law only went into effect last year, we won't really know the ins and outs of automatic expungement until the 1st of July, 2025, when the first of those starts to go into effect. We'll see what happens with those. Anyway, next slide, please. Expungement by petition. This one is a little tricky. It does, again, replace the expungement by vibes process that we were looking at before. But expungement by petition, what this means is if you or the landlord, but typically it's going to be the tenant, come to the court and say, please expunge my record. Just unilaterally, there's not an agreement. It's just the case is over, please expunge it. This only applies to evictions that are based on non-payment of rent and a very specific type of overstaying the lease, where if the lease is written in a way where it doesn't convert into a month-to-month tenancy and that it's just ends at a certain date and you're supposed to be gone. This almost never happens. This isn't how leases are written. So de facto, this really only applies to non-payment cases. So the petitioner, almost always the tenant, requests expungement from the court. The respondent has 60 days to object to that expungement. If there is no objection, it's expunged. Great. But if there is any objection at all, it can't be expunged through petition. I call this the crayon rule because the landlord can write, I object in crayon and file it timely with the court and block this expungement from happening, even if they've lost the case, even if they have brought completely spurious allegations against the tenant and the tenant's able to defeat them. They can shut this process down and force the tenant to either wait on automatic expungement for 3 years or force them into negotiations for things like attorney fees, court costs, whatever, in order to get a stipulation to expungement. Next slide, please. So when these expungements succeed, and they often succeed through stipulation, what happens next? So tenant screening reports rely on third parties called furnishers that go out and scoop up all of this court data and provide it to them. Under Utah statute, the courts will weekly publish a list of expunged cases. The furnishers have a responsibility to update their own records within 30 days. The tenant screening reports need to be updated within 30 days. If they're not, there is a process to resolve that, but it can take some time. Typically, though, it's going to move pretty quickly. So I won't get too far into the weeds about what a dispute would look like with tenant screening reports. We actually haven't seen a lot of expungements or evictions show up where they shouldn't. So this part of the law seems to be working pretty well. Go ahead, next slide, please. And as the statute says, the eviction is considered to have never occurred. It basically wipes the slate entirely clean as if the eviction never was filed in the first place, and you can't find it unless you were party to the case, which is great because this is what allows people to move on with their lives and re-rent without this following them around on paper every time they try to apply to rent new housing. Next, please. So this law is a little bit new, and we're working our way through some of the ways that the statute is written and the way that it applies in real life. So there are just a couple of things that I want to point to here. Like I said, right now we're seeing that landlords get to use the objection clause as a bargaining chip because they know that even if they go through the case and lose, they can still apply pressure to settle out other things and extract more, other money for other reasons from tenants because they hold the power to yes or no on that expungement. At some point, we're looking for a good case where there is an objection that could go up on appeal that could be used to challenge this objection clause on a due process basis, because it's fundamentally unfair that landlords would hold that kind of power over the expungement stage of the process.
The landlord at all.
Yes, exactly. Yep. So as I said before, there will be disputes in 2025 about how automatic expungement works. That is almost certainly inevitable because that part of the statute is written in a way that everyone kind of agrees is a little confusing. So we'll see what happens, but that's kind of a distant horizon problem. There can be these questions that come up with things like when a landlord files for eviction, typically what they'll do is file multiple causes of action. So they'll file an unlawful detainer, the cause that lets you get an eviction order, and also comes with enormous penalties for overstaying the lease agreement. But they'll also file in breach of contract. Unlawful detainer is more difficult to prove. Breach of contract, even if they lose their unlawful detainer claim, they can still come after unpaid rent, damages owing under the contract, that sort of thing. But when you bundle these two things together, you get all of the advantages of an unlawful detainer suit. You force the tenant to have only a 3-day period to respond to the court complaint, things like that. So we're trying to figure out what that looks like if we win an unlawful detainer hearing and get that cause of action dismissed. In the court, it's still coded as an eviction because the suit was filed that way. It's coded EV, and it'll still show up on a tenant screening report. And you can't expunge half a case. So what do you do if you win against unlawful detainer, but there's a valid breach of contract claim, other than fix everything and hope that they'll agree to a full expungement? These things weren't really well thought out when the statute was drafted, but we're kind of looking for creative ways to accomplish these things, like getting the courts to recode those cases as a sort of de facto expungement, that sort of thing. But these are still issues that we're grappling with. And recently, there was a new bill passed in the legislature to kind of append more onto the rights of domestic violence survivors in landlord-tenant law. There was already an existing law that allows for people who are in those situations to compel their landlord to change the locks and break their lease under very narrow conditions. But now added to this is you can do an expungement by petition, regardless of what happened in the case, like what kind of case it was, et cetera. If you were a domestic violence victim and you would have qualified for the lock change protections and or to break your lease prior to when the eviction notice was served, and you've also satisfied the judgment. It's kind of a tall order, but it's certainly better than nothing. And that goes into effect in a few weeks. All right, next slide, please. And that is it. So I know that was a lot of information. I want to leave it open for questions or comments or whatever.
I guess I see a lot of service providers are going to be on there. So it seems like a process that you're kind of on your own. It seems like Clean Slate has a process, because that seems a little more of a complicated process when it comes to criminal expungement. This seems a little easier. It almost seems like a conversation between you and your landlord. And I'm trying to figure out how you would think best service providers can help, like having a discussion with the landlord. What incentives do you think would help getting a landlord to participation in this? You have
This is a really good question. So yes, Clean Slate is fantastic, and unfortunately does not apply at all to eviction expungement. But yeah, in criminal expungement, obviously there's a whole infrastructure there that you kind of have to navigate through. Incidentally, with objections to criminal expungement, that's just one thing that the judge takes into account when deciding whether or not to expunge. It's not an automatic yes or no. So as you pointed out rightly, it's really all about the tenant and the landlord. So yeah, what service providers can do is see about what the landlord is willing to accept for letting this person walk away with dismissal and expungement. Typically, their attorneys will be familiar enough with this process and will just want some basic concessions, like filing fees for the court and that sort of thing. It really depends. It really depends on the landlord's motivation. So it's kind of hard to give general advice on what best to do. But yeah, if a lot of this is going to have to do with the relationship with the landlord and sort of that landlord's motivations more than anything else. So if there is a problem and your tenant is poised to, have a good defense that's based on a technicality instead of an actual satisfaction of whatever the underlying problem was, you might run into a little bit of pushback from the landlord. But I don't know.
That's kind of what I like. It's great that this law is here, but it seems like usually if you have an eviction on your record, that's probably an indicator you're gonna have the most positive relationship with your landlord. And then you're going back and basically asking them if they'll take that off your record. I can only see, I guess, if you possibly owe money, setting up a plan to pay. But
yeah,
I think a place where service providers help a lot is by being that communicator to the landlord as a third party.
yes,
Try to show them the benefits.
yes, yeah.
And it's kind of difficult.
Definitely. No, I mean, and the reason I'm having trouble like giving very clear examples about objections is that the vast majority of these expungements happen through stipulation because the landlord can pressure you into settlement. And oftentimes that lets everybody walk away, at least with everything behind them. So that is kind of what to expect. I guess that is the best advice I can give is temper your, the people that you're serving, temper their expectations about how this process will conclude, because even if they're squeaky clean on whatever the actual underlying issue is, they're still probably going to have to give some concessions to the landlord to get an expungement to happen, which is frankly the most important part of this process, short of preventing the eviction itself. So yeah, that's kind of what to expect.
So for the lock change protection, does that only include someone who was still in the home and changed the locks, or would it also include someone who moved out to get away from their abuser, didn't get their name taken off the lease, and now have an eviction on their name because the abuser was evicted?
Ooh, that's a good question. Whenever there's something with a domestic violence situation, it gets into some really interesting legal questions about just how much you can be liable for the abuser's behavior. Under most lease agreements, everyone is joint and severally liable, which means that whatever one does, the other is responsible for. For something like the ability to petition for an expungement, it's untested, but my suspicion is that, I don't see a big pushback against letting victims of domestic violence try to get the records expunged, even if they were only wrapped into this eviction incidentally, as long as they, of course, qualified for these other protections at the time that would have been relevant right before the eviction notice. So I should talk about what those requirements are. Usually, the biggest one is that they need to be in compliance with all aspects of their rent. So the ability to change your lock to break your lease as a domestic violence protection, you have to be paid up on rent. You have to be in compliance with the lease. A lot of people will come to us and, want to break their lease because they're in a DV situation, but they're behind on rent and there is no way out of that. And that also will prevent them from getting an expungement. Not how I would have written that law, but it is how it's written. So.
And I guess what kind of organizations are working with this? Is there any organization and clients or service providers that you go to for help, like if they're helping?
Yeah.
You talk
Yeah.
about services?
Yes. If you're working in this area, your clients almost certainly qualify for our services. The only big exception is our funding restricts us from helping anyone who is undocumented, unfortunately. So as long as they're a legal resident of the US or a citizen, then send them to ULS. We'll be able to help them through the process. Short of that, there is another organization, People's Legal Aid, that doesn't have those same funding restrictions. They can't do the same kinds of legal services we do, but they can still give you advice on the process. So I think those are the two big ones that I'd point to. Utah Legal Services, which I have cards and brochures and whatnot on the table, probably not useful for most of the people attending online, but we'll get you some contact info.
I guess kind of was wondering that I looked through the participants and I know there are some, I think, from Southern Utah on here. So does Utah Legal Services cover?
Yeah, we cover the whole state. We actually have offices in St. George, although I don't think there's any housing attorneys down there, but yes, we cover the whole state.
You for sure.
Yeah, thank you, everybody.